Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you.
The next section is section 48. This 48 deals with opinion of the court with respect to right or custom, and when that particular opinion becomes relevant. Imagine a scenario where there is a person who has been in that particular village for say around some 70 years, 60 years, and he knows what is a custom or right in that particular village. So the court may ask the opinion of this particular person, and that opinion becomes relevant. And general custom or right always includes rights which are common to any considerable class of persons. In this case, if you would see, if there is a particular community, a specific community, and there are 2-3 classes of people within that particular community, each and every class may have a separate custom or right, and all those general customs and rights would considered as general custom or right, though it is specific for a particular class of community or class of people. Now they are given an illustration. Let us see what is the illustration. The right of the villagers of a particular village to use the water of a particular well is a general right within the meaning of this section. So what they say is, if there is a well which is commonly used by all the villagers, immaterial of their community, creed or caste, then in that case it becomes a general right within the meaning of this section. Now let us move to section 49. This particular section 49 deals with opinions on usage, tenets, etc., and when they become relevant. There may be a body of men or a particular family which is so big in a particular village, a family with huge number of members, say some 100 members or 200 members, and there could be a group of people who are following a particular way or custom of life. So they would have had their own way of usages, their own way of religious practices and everything. So in that case, how a court can form opinion and whether it will be relevant, that is a question. And the next one is constitution and government of any religious or charitable foundations. Imagine there is a religious foundation and how that foundation was formed and how it was constituted, and the governing of all these religious or charitable foundations. And the next one is words or terms used in a particular district or a particular class of people. Imagine if there is a particular language, say a regional language or say Hindi. This Hindi would be spoken in Bihar in a different way, and the same Hindi would be spoken in Delhi in a different way. And the words what they use may be a slang which is used in that particular state or in a particular district. So in that case, what would be the opinion? So in this case, the people who are in that particular area or who have special means to know all these aspects, they can give their opinion to the court, and that opinion becomes relevant.
Section 50 deals with opinion on relationship when relevant. Imagine there is a relationship between one person and another.
So the court has to determine what is the relationship between these two people. So in that case, the court has to form an opinion. So it can seek or try to get the opinion of the people who are very well aware of this relationship, who could be a member of the family or otherwise, or a special means of knowledge on the subject. Then his opinion is a relevant fact. However, there is a proviso to this section which clearly states that this opinion is not sufficient to prove a marriage in proceedings under Indian Divorce Act or in prosecutions under section 494, 495, 497, 498 of the Indian Penal Code. So it is quite sufficient. This opinion is relevant. However, that opinion itself is not sufficient to prove all these aspects. Now let us move to the illustrations which have been provided. Now, the first illustration A. The question is whether A and B were married. So if their friends were treating them as husband and wife, that fact itself is relevant. Next, illustration B. The question is whether A was legitimate son of B. So if the fact that A was always treating this person as a member of his family, then it is relevant. Let us move to section 51. Grounds of opinion when relevant. So this is a very important section. So if there is a person who is giving an opinion which is now relevant, his opinion is relevant, and that person is living. These two things are essential for this section. The person should be a living person and he should have given an opinion, and that opinion should have been relevant. In that case, the basis on which he is giving this opinion, the grounds on which he is submitting this opinion are also considered to be relevant. So expert is giving an opinion based on his own experiments, what he has performed. So in that case, the experiments what he performed or the aspects based on which he has given this opinion are also considered to be relevant. The following sections speak when a character is relevant. Section 52. In civil cases, character to prove conduct imputed is irrelevant. So let us try to understand this in a simple manner. In civil cases, if you are trying to prove the character of a person which is being imputed, then it is obviously relevant. So simply character is irrelevant in civil cases. However, so if there is a fact which becomes relevant, generally it is not relevant, but that fact has become relevant. In that case, if this character appears from the facts which are otherwise relevant, in that case, this character becomes relevant in civil cases also. Let us move to section 53. In criminal cases, previous good character is obviously relevant. As you all know, they call a person accused if he comes to the court and they are asking for bail. They'll say like he is a first time offender or this is the first time he is being accused of an offense. So it means like he has been a person of good character, so bail may be granted to him. So in all these cases, his previous good character becomes relevant. Let us move to section 53A. So in this particular section 53A, evidence of character or previous sexual experience not relevant in certain cases. So imagine a scenario where a person is being charged under the sections 354, 354A, 354B, 354C, D, 376, 376A, 376AB, 376B, 376C, 376D, 376DA, 376DB or section 376E of Indian Penal Code. In all these cases, he is trying to take a defense saying that the character of the victim is not right. She has had many previous sexual experiences with other persons. So he might take this as a defense. However, it shall not be relevant. On the issue of such consent or quality of consent, he may say like that the victim had given a consent because she was frequently having sexual experiences with so many persons prior to this. But that will be irrelevant or that will not be relevant. Let us move to section 54. Previous bad character not relevant except in reply. Imagine in a criminal proceeding, a proof is being brought to the court saying that the accused person has a bad character. that is irrelevant. However, if the accused is saying or he has given some evidence to the court saying that he has got good character, then if the government or the prosecution is trying to prove to the court, no, what he is saying is not right, his character was bad, and they provide some evidences, then in that case it becomes relevant. They are given two explanations. Let us see what are those explanations. The section will not apply to cases in which the bad character of any person is itself a fact in issue. So the fact in issue is about the bad character of that person. So in that case, this section will not apply. Imagine a person in a criminal case, he is accused in a criminal case and he has been convicted in a previous case. In that case, that is an evidence of his bad character. So imagine a person is being convicted for theft in a previous case. Now again he is getting caught for theft and is being accused of theft. So in that case, his previous conviction becomes relevant to prove his bad character. Now let us move to section 55. Character as affecting damages. So imagine in a civil case, the fact that the character of any person is such as to affect the amount of damages which he is ought to receive is relevant. This is a very important section. Imagine the character of a person plays a major role in getting damages. That person is of a good character or he has got very high reputation because of his good character. In that case, the damage what is to be given to him would be much more higher because he has got good values and he has got a good name in his place or in his village, and he is a person of good character and moral. In that case, if his image is tarnished, then the damages which needs to be given to him should be obviously higher. So if that character is not of that character or is not of that good name and fame, in that case the damages could be a little bit lesser. Now let us try to understand the explanations. So the word character used in section 52, 53, 54 and 55, they use the word character in all these sections. So this includes both reputation and disposition, but except as provided in section 54, evidence may be given only of general reputation and general disposition and not of particular acts. Imagine there are 10 acts which a person has done, out of which one act is good. So a person cannot show that particular act saying that, see, I have done a good act. He has done 10 acts out of which only one is good. So that cannot be taken into consideration. So what they have to see is generally what is his reputation. If he has done 10 acts, out of all these 10 acts, majority or the general reputation through these acts is that he is a good person. So that is very important in this particular section. With this, part 1 gets over.
I hope you would have liked the video. If you like the video, please do press the thumbs up button and do share the video with your friends and motivate them. If you are not subscribed the channel, please do subscribe the channel and share the channel with your friends. If you feel that I've left something in this video or you want me to change the way in explanations are given for the sections, please do let me know by way of comments. Let us join hands together and contribute for a learned society. Thank you.